Welcome to Disunion, the Government Union Report, the podcast where we delve into the ever-evolving landscape of public sector labor policy and law. I'm your host, David Osborne, and I'm excited to be your guide through the complex world of government unionization. We bring in experts and individuals with hands-on experience navigating the challenges and opportunities surrounding the unionization of government employees. From the latest legal developments to the practical insights that shape the policies, we've got it covered. So get ready to gain a deeper understanding of the news-making issues that impact public sector labor policy across the nation. James Sherk is director of the Center for American Freedom at America First Policy Institute in Washington, D.C. Under the Trump administration, he was special assistant to the president for domestic policy and served as top civil service reform and labor policy advisor. He was the principal author or policy lead for some 24 executive orders and presidential memoranda. And prior to joining the Trump administration, he was a research fellow with the Heritage Foundation. James, thanks for coming on.
Thanks for having me on.
So I invited James to come on in part because I've long referenced his work. I've known him for a little while, but I've long referenced his work in the Trump administration on what is called revitalizing the federal workforce. And he gave some testimony that I may make some reference to before the Subcommittee on Government Operations in the U.S. House of Representatives, sort of summarizing some of the achievements that President Trump was able to make in the time that James was with him. And you were really, you were on the transition team and then the Domestic Policy Council the entire time, right?
Yeah, I was there all 4 years. I was on the transition team for the Office of Personnel Management. And then basically 2 days after the inauguration, I was onboarded onto the White House and stayed there until a few days before Biden became president. So I was there almost the entire term.
Well, that's quite an accomplishment in and of itself. During that time, as you know in your testimony, job satisfaction among federal employees rose every year, meaning that they seem to be a pretty happy bunch of people in the Trump administration. We're not talking about the Domestic Policy Council. We're talking like civil service, right?
No, that's right. The federal government conducts an annual survey of federal employees called the Federal Employee Viewpoint Survey. And one of the questions they ask, it's a good management tool, just take a temperature of the workforce and how they think things are going in different areas. But one of the questions they ask is, are you satisfied with your job or not? And, typically you get, sort of, mid-60th, percentiles, saying that. But, a bunch of folks don't like it. And what was fascinating is that under President Trump, job satisfaction, federal employee job satisfaction, the career staff, job satisfaction went up continually. And in his last year of office in 2020, hit the highest level it had ever hit at any point under a prior president. So federal employees, whatever they might say on social media or whatever sort of quotes they might send to the Washington Post, on average, federal employees like working for President Trump a whole lot more than they like working for Barack Obama. And for better or worse, federal employee job satisfaction has come down since President Trump left office. And so just based on the federal government's own survey, the federal employees themselves enjoyed their jobs more under Trump than under Biden. It's not what the media would say. It's certainly not what the federal employee unions would say. But a survey of hundreds of thousands of federal employees shows it's the truth.
Now, what made your job complicated? This isn't a direct relationship with federal employees. What made your job so complicated was that there was an entity, a union, that was involved in most of these interactions with federal employees. Several unions represent federal workers. I guess before we talk too much about how you might have dealt with those unions during your time in the Trump administration, I wonder if you could just give us a little bit of history. How did unions come to represent federal employees in the civil service in the first place?
That's an excellent place to start. You've got about 3/5 of federal employees, 1.3 of the 2.3 million civilian federal workers are covered by unions. And if you knew a little bit of history, you might say, how in the world did that happen? Because, in the private sector, unions became very large, under President Franklin Roosevelt. He signed the National Labor Relations Act, seen as a champion of unions, a champion of labor. But even he said, no. Government is totally different. You can't take this private sector model and transport it in the government. The government has unique needs and obligations to the country. Unions, thank you guys, but you don't really belong here in the federal government. And so how do you get to a position where 3 in 5 federal employees belong to a union that has pretty significant legal power over government operations? The short answer, as with much going on in government, is politics. JFK, when he was running for president, saw the unions as a potential power base, potential supporters for him and his administration. There were some groups that wanted to be, they were sort of employee associations. They had members who were federal unions. They wanted to actually get sort of the powers that private sector unions got. And he promised them that he'd sign an executive order unionizing the federal government. And in 1962, he did exactly that. And it was basically a payoff to campaign supporters and to a larger extent, trying to create a sort of power base. But what's interesting, though, is if you read the original Kennedy executive order, the words collective bargaining never appear anywhere in the text of that order. Kennedy was very mindful of the constitutional responsibility of the president for the executive branch, and the entire system was set up to be subordinate to presidential direction. Anything that he wanted them to bargain over, they could bargain over. Anything he didn't want, we're not going to talk about that. The unions had no rights to strike, no rights to shut anything down. There was no arbitration. Actually, I think the arbitration might be wrong there. That might have been Nixon who added that in. But the point was everything operated under plenary presidential control. So if something wasn't working or a contract came up the president wasn't happy with, he could just say, we're just not going to do that. Nixon took office in 1969. He expanded the collective bargaining to some extent. But then what happened was you had Carter got elected on a civil service reform plan. And he was pushing for measures to address what are still today, unfortunately, big problems with the government not being able to get rid of poor performers, a lack of basically good leadership in the senior ranks of the senior executives in the federal workforce, and a lack of the flexibility in how you address some of that. And so he had this Civil Service Reform Act plan. And he wanted to create what is now called the Senior Executive Service to give agencies more flexibility. He wanted to make it easier to fire poor performers. And basically, the union said, all right, if you want us to accept this stuff, we want a payoff. And that payoff is you're going to write in statute all of our powers and give us even more power than we had before. And Carter said, oh, that sounds good to me. I get what I want, you get what you want, and let's make a deal. And that's exactly what happened. So the Civil Service Reform Act of 1978 both codified and expanded on the Kennedy and Nixon executive orders, and it was all part of a political horse trading. But if you were to rewind the clock, even 40 years, people would say, well, of course you can't do that. You can't have the unions of the federal government, right? The government is unique. And it is. But, that was not allowed to get in the way of politics. So that's the short history of how unions came to the federal government.
All right, got it. So one of the problems that I know exists, but you hit on it just a moment ago, is to what degree do unions impede the power of the president to make quick decisions? I know in the Federalist Papers, we talk a lot about the president needing to be a unitary executive. It's important because we need to know who's going to make decisions, and it allows them to move efficiently and quickly. Unions, sounds like we're already getting to the point where unions may be in the way of that kind of.
Oh, yes. And I do think that the powers that the federal unions enjoy under federal law are inconsistent with what the court has said about the Constitution vesting executive power of the president. And look, no president has ever challenged the union's powers, so the courts haven't examined it. But if you take a look at what they've said in other contexts, it's hard to see how the powers the unions enjoy are constitutional. So one power they've got is once an agency and a union enter into a collective bargaining agreement, that contract is going to last typically for 6 to 10 years. The contract, the basic term itself will be about 3 to 6 years, depending on the agency. But then the contract stays in effect while it's renegotiated, and that process takes about 4 years. So actually you're looking at about a 7 to 10 year lifespan for these contracts.
On the state level, we call that the status quo obligation. Is that same terminology?
Well, it's similar. They'll have what are called continuance clauses, right? So there's a totally separate doctrine called the unilateral change doctrine, which basically says even if it's not in the contract, you can't change anything until you've bargained. But just categorically, if something is in the contract, you can't change it without the union's permission for the better part of 2 to 3 presidential terms. And so you could have something like, say, a real example here. So Congress is very upset with performance at the Department of Veterans Affairs. President Trump campaigned on it because you had some horrific mistreatment of veterans and horrific behavior. Veterans were dying. The Obama Veterans Affairs Department was seen by a lot of people as being completely failed. And so he comes into office, and your first 6 months in office signs the Veterans Affairs Accountability Act. Among other changes, this law says that you don't have to give a poor performer at VA, at least if they're in a medical position, what's called a performance improvement period. You can fire them right away. You don't have to give them a 90-day performance improvement period before you can say, you're no good treating veterans, you're gone. Wonderful. They've changed the law. And before that, it was a legal requirement that you have these performance improvement time periods before you fire a poor performer. And so it still applies for the rest of the federal bureaucracy, but it doesn't apply anymore to VA. Fantastic. Trump administration goes out and starts laying off poor performers at VA without giving them these PIPs. And then the AFG, the American Federation of Government Employees, the largest federal employee union, represents a lot of workers at VA. And oh, no, not so fast, Mr. President, not so fast. You see, our contract calls for a 90-day PIP. So we don't care that Congress has changed the law. They didn't repeal the law that allows us to exist and collectively bargain. And under absolutely no circumstances are we allowing you to fire a single one of our members without giving them a 90-day performance improvement period. And that holding was actually upheld. It went to arbitration. The arbitrator ruled for the unions, got appealed to the Federal Labor Relations Authority, and they upheld it. And as a result, the Biden administration agreed to a settlement where they reinstated every single poor performer fired without a PIP and gave them back pay. I mean, it was just an incredible result. The fact is, anything that's in a contract, the president can't touch until the contract expires and is renegotiated. And it takes a presidential term to renegotiate them.
Regardless of the merits of the particular law here, the procedural reality is that it cannot go into effect if there's a contract that's been in place that covers that same subject.
Exactly. Once the contract expires and is renegotiated, then a government-wide rule or what have you can supersede it. But unless Congress has passed something that says our law supersedes the union contracts, which they didn't here, it was just silent on the question, then the union contracts prevail. And so could be an executive order, could be some sort of rule from the Office of Personnel Management, could be whatever the policy is, the union contract gets to wait it out. And you'll be shocked, absolutely shocked to know that the unions drag out negotiations if it means that there's a rule that's going to be implemented that they don't want. We saw this all the time in the Trump administration. The unions basically dragged out renegotiating the Veterans Affairs Department collective bargaining agreements for 6 years. So it lasted beyond. They reopened the contract in 2017, shortly after they passed the Accountability Act, and spent the entire term trying to renegotiate the contract. And the union just kept playing one delaying game after another to stop that from happening. It's an incredible power where the unions have veto power over agency operations.
Well, let's zoom out a little bit. So we got specific. I think the general point was that the union here is actually impeding the unilateral executive authority to get shit done. But another general problem you kind of mentioned here was poor performance. And it's certainly related to that. But you touched on this idea that getting rid of poor performers in an agency is not just about taxpayers, and it's not just about the president, being able to run his administration. It's also about other federal employees who are sitting next to perhaps a poor performer, maybe making up for their failure. You said in your testimony that federal employees are reporting a lack of confidence in their agency's ability to address these issues around poor performance. Tell me first, I guess, how do unions, you may have mentioned it with that VA example, but how are unions protecting in general these poor performers and keeping them from getting fired?
So the unions get to do two things. First of all, they get to negotiate all these procedural realities around how an agency is going to fire a poor performer. So the union can't say in their contract, you can't fire Bob. They can't say this specific guy gets hired or fired. But they can say, here's the process you're going to go through to determine if Bob gets hired or if Bob gets fired. And you'll be shocked to know that they make it a very long and drawn-out, protracted process. Prior to Trump coming in, the CBAs uniformly, or nearly uniformly, required what's called a performance assistance period. So before you could put someone on a PIP, the union contract would specify a separate process called a PAP. And, oh, by the way, if the combination of the PIP and the PAP overlap with the performance appraisal year, then you have to restart the process again, in the new year. And they would specify anywhere between 60 to 120-day PIPs. It was a very long, protracted process. And it makes it very difficult and costly for the supervisors to use. The second thing the unions do is then, once you've gone through that process, they can file a grievance. And the grievance is heard by an arbitrator. And the unions help pick the arbitrators. And shock of shocks, the arbitrators want the unions to help pick them again. And so the arbitrators are constantly looking for ways to split the baby. And even if the agency's got an employee dead to rights. Well, but firing Bob would just be too extreme. We agree his performance was suboptimal. But you should give him a suspension or something like that, right? Like, they always look for ways to split the baby. This was a complaint that I was hearing in the White House from career staff who are not at all conservatives, nowhere close to being conservatives or on the same place politically I am, but really frustrated with how these arbitrators would just be constantly overturning disciplinary actions for employees who they felt were hurting the agency and its mission. And it's not just anecdotes. We actually did a FOIA request and got hundreds and hundreds of these arbitration awards. And we found that in about 3/5 of cases where there's a proposed removal, the arbitrator overturns the removal. And in some cases, they just completely overturn everything. In other cases, they downgrade it to a suspension. But in general, it's a pretty friendly forum for the employees if you can get your union to represent you. And by the way, the agency has to pay the union to do this. They get official time to represent you through the grievance as well. And so the government, the agencies are paying unions to appeal before a very union-friendly forum to get poor performers reinstated. I think it's absolutely insane. And the other thing is, if the employee loses before the arbitrator, they can file an appeal to federal court. But if the employee gets reinstated, the agency can't appeal. And so the agency just has to, real example, let's say you've got an employee with the Department of Veterans Affairs who is arrested and pleads guilty to possessing meth with the intent to deliver it. You might think you could fire someone for that. The agency might have thought they could have fired someone for that. But you would have been wrong. In fact, if you'd been that agency, you'd have had to reinstate that employee. I mean, it's crazy, and the agencies can't appeal. And so you just get these loopy decisions by arbitrators trying to curry favor with the unions.
Now, maybe this is a dumb question, but a lot of people probably wonder, what about the Civil Service Reform Act? Wasn't there already a process in place to help people in the civil service sort of grieve, for lack of a better term, grieve their termination? Or
there was. Prior to this, you had what was called the Lloyd-La Follette Act, which provided for a process, but was not. You didn't have the same level of appeals that you have under the current process. Right? If you weren't a veteran, for the most part, the appeals were being held, being done within the agency. Although I think by the end of it, I think Nixon might have moved everything to the Civil Service Commission. But at the end of the day, for the most part, the employees, as long as you check the box procedurally, did not have access to court. And at the end of the day, it was the presidential appointees who were doing this. Now what you've got is it's a choose your own adventure. You can, if you wish, appeal through a significantly beefed up appeals process with the Merit Systems Protection Board, or you can file a grievance with your union. And if you're in a union, if you're in the 3/5 of the workforce who are unionized. And that grievance is going to be heard by an arbitrator who your union is going to help pick. And that arbitrator is going to feel a lot of economic pressure to try and split the baby. And as a result, you just get employee after employee after employee who gets reinstated. Another example, unfortunately a real example, Department of Veterans Affairs, another employee was a nurse who was found to have interfered with a patient's basically a medical treatment, a care line, I should say. There was non-medical treatment that was being provided, basically therapeutic type treatments that were being provided to help this patient who was a veteran who, I believe it was PTSD. I'd have to double check that. And she obstructed with it. And then when the manager found out, because the patient came in just crying and sobbing and asked what he'd done wrong and why he was being treated this way, she took a look at what was happening and found out very quickly that he'd been taken off his treatment plan. And then she lied about it during the investigation and lied for a while until finally the truth came out. And so again, you'd think that if you're the director of that VA facility, you could remove a nurse who willfully obstructed a patient's treatment and then lied about it. And you would be wrong, because an arbitrator ordered this nurse reinstated with back pay. And that is just the reality of the civil service system under the laws that Congress has passed.
Okay, so what's the fix? What do you do about that?
I mean, look, ideally, I'd say you just get rid of the entire Chapter 71 of Title V, and if the president wants to do collective bargaining, he can. You want to do executive order, structuring it that way, you can. If you feel the need to make tweaks, go for it. If you don't want to do it, don't. I think that's the immediate fix. A secondary fix would be at some point, someone launching constitutional challenges to some of the authority given to the unions and given to the arbitrators. Look, if you look at what the courts have said under what's called the private non-delegation doctrine, the arbitrators, like black letter law, cannot wield this authority, right? That under the private non-delegation doctrine, private parties can't wield federal executive power. They can be assistants, they can be aides, they can give suggestions and advice, they can do sort of like the grunt work, but the guys who are making the call and exercising these sort of decisions on core exercise of executive power need to be someone who reports to the president. And the arbitrators don't do that in any way, shape, or form. They're basically private contractors, for the most part attorneys, getting paid to do this on a one-off basis. And if their decisions are concerning a removal or a dismissal or a long-term suspension or a demotion, there's absolutely no supervision by anyone in the executive branch.
I think I also looked into at one point what it takes to become an arbitrator. and one of the requirements was that you needed recommendation letters from unions.
Yes.
Yeah.
And then even on the things that aren't these core disciplinary actions, the standard of review is extremely generous by the FLRA. Basically, you have to have completely ignored the law or your decision's going to stand. And that's a statutorily required deferential standard of review. If you're, quote, even arguably applying the contract, then your decision must stand with no further question, right? So the almost unreviewable authority that they have in stuff outside of disciplinary matters and the completely unreviewable authority they have in disciplinary matters, you just can't do. The Constitution doesn't allow Congress to take the president's executive power and give it to a private party with no supervision from anyone accountable in any way to the president. And so I think the unions are extremely vulnerable here to a constitutional challenge. Again, TBD what will happen. No one's brought that challenge to date, but given what the court's been saying recently, and then a lot of the circuit courts, there's been a lot of active litigation in the past decade or so on this private non-delegation doctrine. And it's all coming out the same way. It's all basically saying, yes, private parties can't exercise executive power. And so we'll see what happens. But I think the unions are skating on the thin constitutional ice here with the degree of power they're trying to exercise over the executive branch.
Well, I've seen them actually growing under Biden. The Bureau of Labor Statistics reported that the unionization rate in the federal government may have been one of the only unionization rates that's gone up. And it's gone up very slightly, but has gone up because Biden has made it a point to encourage membership and perhaps even strengthen the power of the unions under his watch.
Yeah, no, they have. I mean, they had a very open initiative to try and boost union membership in the federal sector. They're doing everything they can to encourage employees to pay dues. I know it does seem that their gains here have been a little bit overstated. You had a press release coming out from the White House. I think it was under Kamala Harris, who was part of the task force here, boasting that union membership had gone up massively. I think this was in January or February of 2023 that they'd gained something like 100,000 members or so, or big gains in the membership. And we took a look at that because the unions are required to file these financial transparency reports. And what we found was that there was a very small increase that was nowhere close to the gain that the White House had shown. And even more interestingly, if you looked under the hood, the biggest union, AFG, had lost a bunch of members. And the other unions were growing. NTEU and NIFI and a few others were growing. But their gains were more or less offset by the hemorrhaging in AFG. And you might say, what's happening with AFG? Well, it turns out the president of AFG in 2020 or 2021 was basically forced out of office in a massive sexual misconduct and corruption and embezzlement scandal where it looks like he'd been using AFG members' dues to do things like pay for limousines to visit prostitutes and just lots and lots and lots of member dues unaccounted for and lots of abuses of power, sexually harassing his personal assistants, horrific allegations of sexual misconduct against people connected to the union. And the entire union executive board, per whistleblowers, I don't have firsthand knowledge here, but per folks involved with the union, saying that a lot of folks in the union high command were totally aware of what was going on and were just playing hear no evil, see no evil. And reportedly, again, per these whistleblowers, the number two, who is now the president of AFG, Everett Kelly, was totally aware that the stuff was going on and was actively an active participant in some of the cover-ups. So if I were a union member in a fully right-to-work job and found out that that's how my union was using my dues to, procure services of dubious morality, and it wasn't just a bad apple at the top, but everyone in the leadership ranks reportedly was totally aware of this and just ignored it, I might not want to continue paying those union dues. And so AFG has had some membership problems in recent years, and I think they earned it.
Well, let's shift just a minute to talking about, I know that perhaps getting rid of employees or getting better ones instead or whatever, that's part of efficiency. But you addressed efficiency more generally. And, if someone were to say, agree with you that the government should be efficient, but still not want to see employees fired, there are other avenues for getting that done. Can you go through some of what you recommended and some of the things that were implemented to increase efficiency among the federal workforce?
Well, look, one of the issues you've got here is with this use of official time, which is where the agencies pay the unions to perform union business on the clock. And not only do they pay them, or they pay government employees to do this union business, around 1,000 or so federal employees perform solely union business, which means they're not doing any work for the agency. And if you didn't do your day job for 5, 10, 15 years, you might be pretty bad at your day job. And then what happens if you lose your election to the union and need to go and do your day job anymore? Oops, I've forgotten how to do it. And that's not a hypothetical. That's something that actually happens. We heard from the Department of Veterans Affairs that they had an employee who was performing union business nonstop, and then the rank and file didn't like this person, and they lost their job, and in the union had to go back to their day job, and they didn't have the skills to do it, and they had to be sent into retraining. You had another case where you had a licensed practical nurse who was flu season, and they said, hey, could you come off union time and just help administer some of these vaccines for the flu because we're shorthanded? And the nurse wasn't being a jerk, but her response was, I'm sorry, I'm not legally allowed to do that because I've been only doing this union business and I'm not legally allowed to treat these patients, right? She wanted to do the right thing, she just couldn't, right? Like if you've got a framework where government employees are spending all of their time doing non-government business, and then every so often they lose the union election and have to go back to the agency, that's not terribly efficient.
All right, well, I have to stop you here. So James is mentioning something that is shocking to a lot of people still. I happen to be very well aware of it, but it's a problem. They call it official time within the federal government. There's actually a statute that authorizes this. There's something that's very similar to that's been implemented in the state level, and some states authorize this as well. But it actually happens state to state all the time without any authorization. In the federal government, the statute has a lot of play in the joints to where there are certain activities that federal employees will do that they are authorized to get leave and leave their office in the government and go do this work for the union and still get paid. They don't lose anything. They get all the benefits. They get all the retirement. They're statutorily authorized to do that. If you're going to have unions, I understand why this might be desirable for the unions, and yet doesn't necessarily follow that as a policy matter that the government should have to pay for it. Leave makes sense, but perhaps payment was a little over the top. Even worse than that, though, there's a provision of that official time statute that, James, you did some specialized work on that allows the government to basically agree with the union to a reasonable, whatever that means, a reasonable amount of time for union officials to leave their office and then go and work for the union full time. Same deal, but without this statutory authorization, or at least without a specific statutory authorization. It's reasonableness driven, and that's inherently very hard to track and very hard to enforce. So I wonder, on that particular provision, what did you come up with to try to contain some of the costs and enhance the efficiency of the government there?
Yeah, no, it's crazy, right? The unions are allowed to bargain for quote-unquote reasonable amounts of official time, and you'll be shocked to know that the amount that they consider reasonable is always more. And you have thousands and thousands of employees government-wide spending a good chunk of their paid duty hours doing this union business. And the Biden administration has made a point of not updating these figures. In fact, I'm reliably informed by people in the Department of Veterans Affairs that they are forbidden to track the amount of official time being used by the union representatives. It's not just that they don't know, they don't want to know, and they don't want to be able to calculate it. But prior to the Biden administration, you had around 1,000, 1,200 or so federal employees on 100% union time. And you're using this to pay for filing grievances, doing, negotiating like Mickey Mouse stuff. And it's just like everything the union does is subsidized. And in many cases, the union is just using it and it goes into a black hole. You have no idea what they're using it for. A lot of these folks in 100% official time work from home, work remotely. And so they could be doing anything. And there's just no accountability into the agency. And it's a massive suckle of money worth about $200 million a year. And, we have a little bit of a financial problem here. And it's one thing to say, all right, unions are allowed to represent employees, but maybe the members should sort of pay for the freight if they're receiving the benefits from it. And maybe we shouldn't just have a massive $200 million subsidy that also makes it very difficult for the employees to then perform their day job if they leave their union offices. I mean, it's just... and so in terms of what President Trump did, he did a few things. First of all, he said through executive order that because a lot of the stuff is being negotiated, that he could put parameters on it, because once the contract expires, a government-wide rule and executive order supersedes union contracts. So once he said, here's the box, you couldn't go outside of it. So he did a few things. First of all, he said, we're not going to pay you to file grievances against the agencies anymore. You can do it, But you have to decide that it's worth spending your money. Don't spend the government's money to file these grievances. And you again, be shocked to know that grievance activity was perhaps a bit different after that. Secondly, he said, we're not going to pay you to do lobbying. Lobby on your own dime. Don't lobby on the agency dime. And then also importantly, he said no more than 25% of any individual employee's schedule can be spent on official time. So you have to spend at least enough time on your agency business to maintain your skills and be able to still do your agency job well. You don't just completely clock out and say, I'm on union business and I'm doing that for the next indefinite 10 years or what have you. No, at least 3/4 of your time has to be spent on agency business. You can spend up to 1/4 of your time on union business. But know your job, know your skills. Don't just check out of the federal workplace. Now, the unions, you will be shocked, absolutely shocked to know, reacted to that the same way that Count Dracula would react to a garlic lepers pizza. They proclaimed it a threat to democracy and a dictatorship, and this was just the worst thing they'd ever seen since sliced bread. They sued over it. The courts basically said, you don't have any standing to sue right now. Go away. And then it got litigated through the Federal Labor Relations Authority, and the FLRA said, of course he can do this. Statute says he can do this. But by the time we got that ruling, basically the clock had run out and the Biden administration took office and Biden rolled all this stuff back in fairly short order.
So I'm curious, maybe this takes us right back to the beginning of our discussion. But last question, you've got these problems in the government union workspace, and you had a president who wanted to reach out to unions, who wanted to show unions that we cared about average workers and particularly blue-collar workers. Maybe that's the answer. But how do you go about, in your time working in the Trump administration, distinguishing between these kinds of reforms, which may be bad for certain unions, and certain types of reforms that might help blue-collar workers?
Well, I think the thing to recognize is that the federal unions are not representative of the average federal employee. They're representative of the employees who join the union and pay dues, which is only about 1/5 of them. And you might ask yourself, why would a federal employee join a union and pay dues? They can't negotiate pay for the most part because that's all set by the general schedule. They're not negotiating over your pension benefits. Again, that's set by law. What is the value of joining the union and paying dues? And even with the subsidies, it's still $700 or several $100s a year worth of dues. And the answer turns out to be two groups of people join the unions in the federal government. One is basically hardcore progressive ideologues who just believe in we must have solidarity. And those are the folks who tend to operate, fill up the union leadership ranks. But that's not where most of the membership comes from. The value proposition that pitched to the rank and file is we are your insurance policy. We are the ones who will protect your job and make sure you can't ever get fired. And the man will never take away this awesome job that pays so much away from you. And if you look at some of the union blogs, quite literally, they're saying, here's how you make the pitch. If you had a house, David, worth $500,000, would you be willing to pay a few $100s a year in insurance on that house to make sure if it got burned down, you'd be compensated? Well, yes, you would. Well, what is the value to you having your federal job for the next 20 years and making sure no one can take that away? If you join the union, you get all this amazing grievance protection, and we can grieve your case to binding arbitration, and you'll probably get your job back. And we have experts who know the ins and outs of all these federal personnel laws. Yes, you've got these civil service protections, but we're the ones who know how to work them to make sure that you absolutely don't get separated from your job. And so I don't think it's an accident that the proportion of federal employees who join unions is roughly equivalent to the proportion of federal employees that think that there's not a problem with poor performers in the federal workforce. And it's basically the people who feel that they might be fired from your agency who see value in joining the union. If you're a hard worker, you're doing a good job, what are you paying for? Right? Like, the agency's not going to try and fire you, and civil service laws are going to make that hard if you could. But if you're the employee who thinks that actually they might have it out for you, then the union actually starts looking pretty attractive. But that is extremely not representative of the federal workforce. The federal employees, most of the line rank and file employees, who again mostly are not conservatives, have had it up to their neck with the poor performers and the folks who are not carrying their weight or don't know how to do their job or playing solitaire all day. I mean, one of my favorite statistics from my time in the Trump administration is President Trump issued an executive order in May of 2018, decided to make it easier to fire federal employees for poor performance. Didn't make them out well, but streamlined the process, made it faster and quicker. It was issued the same day as the executive order reining in some of the official time abuses. And a trade magazine for the federal workforce here is called Government Executive, a trade publication, spent how much money, I don't know, to get a statistically representative sample of federal employees and ask them about this executive order. And did they approve or disapprove of this executive order making it easier to fire poor performers? 2-to-1 support in the federal workforce. So at the same time, the unions were running around screaming their head off about how this was the end of democracy and this is an assault on federal employees and Trump is a savage dictator trying to make it easier to fire a poor performer with only a 30-day PIP instead of a 90-day PIP. The federal employees themselves, who the unions purport to speak for, loved it. That's the reality, is the unions represent either ideologues or poor performers, and very few other people see much value in joining the union in the federal sector.
Excellent. Okay, well, let's close there. James, is there anything that you want to share here? Any way that we can follow you or see what you've been working on?
Well, thanks. So I'm a director at the Center for American Freedom at the America First Policy Institute. So if you go to americafirstpolicy.com, you can find a lot of my work on these and other topics. And anyone who's interested, that report I mentioned on arbitrators overturning most employee dismissals when the unions grieve them, you can find that there.
Gotcha. Well, I recommend checking out James's testimony here that I mentioned at the outset. If you just Google James Sherk Committee, it probably comes up. But it's the Subcommittee on Government Operations, Committee on Oversight and Reform, U.S. House of Representatives. What I like so much about it, James, is that you gave specific detail to describe some of the policy reforms that came about under the Trump administration. With the media that we have now and with all the noise out there, it's so hard to find stuff like this. And you put it all in one spot. So it was a great benefit to me. Thank you. And that's a wrap for today's episode of Disunion, the Government Union Report. We hope you found today's exploration into public sector labor policy both insightful and thought-provoking. Special thanks to all of you for tuning in. If you enjoyed today's discussion and want to stay informed about the latest developments, don't forget to subscribe to Disunion, the Government Union Report, on Spotify or your favorite podcast platform. Your support means the world to us. I'm David R. Osborne, reminding you that understanding labor policy is crucial for shaping the future. Until next time, stay informed, stay engaged, and keep making a difference.